We live in a world driven by data. In every aspect of our lives, we are leaving behind an enormous trail of data which might contain sensitive information that pertains to us. These information flowing across the corporate giants have ability to directly or indirectly affect us. So one might ask, is our data sufficiently protected here in Europe? Are the corporate giants ethically using our data? Well, to answer that question, we need to know a little bit about the pretext. Most of the user data from Europe, with a speculation of almost 90%, is being processed in the data centers located in the US. As this trend was getting more common, in the years of 1998 to 2000, some principles were made and would be agreed upon by the European Commission and the United States. These principles were made to ensure that the transatlantic data were kept secure and that the private organizations in Europe and the US were prevented to accidentally or intentionally disclose or lose personal information. So, this would enforce corporates to follow various compliance protocols to protect any form of personal data. These principles were named International Safe Harbor Privacy Principles. As time passed by, internet started getting bigger. The world became more connected through these technologies. Any large service providers, such as Facebook, could harvest massive amounts of user data for their financial gain. And that is exactly what they were doing. Although the International Safe Harbor Privacy Principles were made and enforced upon, it failed to adapt with the growth of the internet. Ultimately, the users started getting threatened and insecure with regards to their personal data. Meanwhile, an Austrian data rights activist named Max Schrems also alerts everyone that through these very technologies, the US government has been collecting massive amounts of data for surveillance and that these data have commercial value to the corporates. It is also interesting to know that until now, the US government does not have a central level privacy law. So that means there would be no legal protection to somebody if his or her data is found to be exploited by the US agencies. Interesting enough, in 2011, Max Schrems, who was then a legal scholar at a university in California, had requested Facebook to give him his personal data, to which Facebook agreed upon. To his astonishment, it contained about 1200 pages of his personal data, every data he had ever liked, and even his personal messages. He also realized that how corporates could use their power to unapologetically disregard a person's privacy. So, keeping this in mind, Max Schrems filed a lawsuit against Facebook and he has been chasing them since then. The lawsuit went all the way to the European Court of Justice. On a better note, Max Schrems won the case, resulting the abandonment of the existing international safe harbor privacy principles. The major drawbacks seen were the ability of US government to exploit the personal data and the lack of judicial support for EU data subjects. Consequently, on July of 2016, a new signing was done between the European Commission and the US, which was named EU-US Privacy Shield. It was made to bolster the regulations in regards to the transatlantic exchanges of personal data between EU and the US, and to address the shortcomings of the previous international safe harbor privacy principles. The principles of this understanding were as follows: notice, choice, accountability, security, data integration, recourse, and liability. Any organization accessing the EU data now had to comply to these above principles. Meanwhile, on 25th May of 2018, a new data protection regulation was to be announced by the European Parliament and the Council of the EU. The regulation was named General Data Protection Regulation, or in short, the GDPR. This widened the horizons and expanded the compliance protocols to data processors all over the world. It defines what companies can do with our personal data. It gives us more control over how our data is collected and used, and forces companies to justify everything that they do with the data. So, is this what we were looking for? Well, it's a complicated question. Popular activists Regulators and researchers claim that the regulations in the US is still at its rudimentary level. They argue and claim that the corporates in the US are still using personal data for capitalization and for surveillance. On top of that, the almost non existent US privacy laws shield the companies in doing so. What we should also know is that the Privacy Shield was signed despite its shortcomings. The Article 29 Working Party, which is an advisory body made up of a representative of Data Protection Authority of each EU member state, the European Data Protection Supervisor, and the European Commission, had launched this framework on a trial run basis, meaning that the Privacy Shield would be under scrutiny until we reach to a situation when the existing concerns are addressed. The major concerns that the data protection activists and the Article 29 Working Party show are as follows: lack of measures taken by the US for privacy protection, extension of the US surveillance programs as revealed by Edward Snowden, lack of rule in terms of certain data processing, and that it is not future proof. Also, the GDPR is criticized as a huge amount of data breaches were noticed, overburdening the data protection authorities and the failures to address issues in regards to inferencing. So, as a conclusion, one could say that the government and the authorities have been taking actions and steps to ensure privacy. However, there seems to be a problem in regards to corporate ethics, be it in Europe or anywhere else.